make sure that our speakers is on. You've got yours turned on? Your microphone? I don't have it turned on yet. Okay, there you go. I'll go ahead and get it's live. Well, good afternoon, everyone. My name's Eric. See if I only get the one channel. Is that better? Okay, my apologies. For those that didn't hear me before, I'm Eric Norberg. I'm the Dean of the Paul Meek Library. Happy to have people here as part of our UT Martin Research Series. It's a beautiful day outside. You had other options, including goat yoga, so I know that it's an extra effort to be here today. I appreciate that. We developed this series last year as a way to highlight the research that's going on amongst our faculty and staff on campus, and also research that includes student in their learning environments here. I think sometimes it's a misnomer that UT Martin is a teaching school, and we do a great deal of teaching here, and we do a really high quality teaching approach here at the university with small class sizes. But I think for those that aren't aware, all of our faculty are expected to participate in research and scholarship, creative works, and some of our other departments. And they produce a lot of different things, from articles in peer-reviewed journals, books, performances, creative works in the arts and humanities. And so this series is really kind of trying to highlight that activity as we go. We have a couple of events coming up to finish off the year. We'll get some more details out for those. You can follow us on our library webpage, on Runway, on Facebook. But in November, we're going to have a report out from a student-led research project in the College of Business. How many here remember a thing called the Pepsi Challenge? Well, these students are going to undertake a similar project where they're going to do a Mountain Dew challenge. And they're going to have people with blindfolds on taste different citrus drinks and try to figure out which one they like the best. The students are going to crunch the data. It's a marketing class project that they're doing with Dr. Christian Burschardt in business, and then they're going to report on that project here in November. So have a look. If you get a chance today before you leave or when you're on campus, we have an exhibit over in our special collections area about the history of Mountain Dew. So it's a tie-in to that. If you don't know it, Mountain Dew is a Tennessee creation. So you can learn more about that in our special collections area. And then in December, we're going to finish out the series with a report out on a survey project that our special collections department did with funding from the National Endowment for the Humanities, looking at historical records collections across West Tennessee. And Sam Richardson, who's our tenured faculty member in special collections, will be leading that event. So, but on to today. Before I forget, if you haven't been here before, restrooms are down at the end on the left. There are some refreshments. Feel free to get up and get some of those as we go. But I'm going to turn things over right now to Dr. Anderson Starling, who's the department chair of a long-named department, which I never remember all the pieces of, but he's going to give an introduction to today's speaker.
Thank you, Dr. Norberg. I'm Anderson Starling. I'm the interim chair of the Department of Accounting, Finance, Economics, and Political Science. And I am delighted to introduce to you today our speaker, which is Dr. Patrick Baker, who has a JD. He's an associate professor of law here at the University of Tennessee at Martin. A little bit about him. He joined our UTM faculty in 2016 and currently teaches law within the College of Business and Global Affairs. In the summer of 2017, he was served as a visiting scholar at Queen Mary University in London. In 2022, he was named the Ray and Wilma Smith, or he received the Ray and Wilma Smith Award for Scholarly and Teaching Excellence. And in 2021, he was awarded the 2021 Cunningham Outstanding Scholar and Teacher Award and the UT Alumni Association Outstanding Teacher Award. Before joining UTM, Patrick served as an associate professor of law at the Appalachian School of Law in Grundy, Virginia. There, Patrick was appointed the inaugural director of the Natural Resources Law Center. He taught administrative law, hard mineral law, legal research and writing, oil and gas law, and water law, which all sound fascinating. Before joining academia, he practiced at one of the oldest law firms in Virginia, Penn, Stewart, and Eskridge. Did I say that right? Yep. In Abingdon, Virginia. His practice focused on employment, regulatory, and energy law. He earned a BA in history and minored in psychology at the Virginia Military Institute and was awarded his JD at the Appalachian School of Law, cum laude. His scholarship focuses on business, property, environmental, and energy law. He is licensed to practice law in both Virginia and Tennessee. His articles have been published by leading law journals and publications such as BYU, Journal of World Energy Law and Business, West Virginia University, Vermont University, and Oil and Gas and Energy Quarterly. He's been interviewed and quoted on legal issues by national and international publications, including the London Times, the Washington Post, the Associated Press, U.S. News and World Report, ABC News, and the Richmond Times. Please join me in giving Dr. Patrick Baker a warm welcome this afternoon.
It's hard to sit there and listen to people talk about you like that. It's very I don't know, but Anderson, you did a wonderful job. Thank you. And Eric, thank you for putting this together and all your hard work. I've been very blessed to be here at UT Martin. I've had a tremendous amount of support from my department chairs, my deans, the chancellor, the vice chancellor, as far as my scholarship and research. And so even though I'm the one that is up here presenting, there's a lot of people that have gone into that to have that support. So I'm very appreciative of the University of Tennessee at Martin. Very appreciative of the students and the colleagues. I've got quite a few students here today. They're so motivated to learn about the law that they've carved out this time today. Not that the extra credit, you know what I'm saying? Not that. I did tell them though when they came over here for this, I said what you should do is create a minor buzz and make sure you should talk about how inspirational I am and how interested you are in the law. I said your number one is to make me look good. All right, so just make me look good. And then you can get some extra credit points. But anyway, thank you so much for being here. I appreciate you being here. I appreciate your time. And so when I was asked to do this, I thought about different topics, and so I went back and forth because I have a lot of experience in the energy law, and I thought I could talk about climate change, I could talk about energy law, and I could get into the weeds on some energy law issues, and I thought that's not very broad, and I don't know how much appeal or interest that would have. And so I settled on this topic because I think it spans across all our disciplines because it deals with accreditation in higher education. And so how this topic kind of came about is in 2015, I guess it was either 2014 or 2015 when I was at the Appalachian School of Law. We went through the accreditation process with the ABA. And it was very arduous. There was a year build up, thousands and thousands of documents. And so what was interesting about it was the fact that this process is completely controlled by a non-governmental organization. So the way that it works is the Department of Education says, ABA, you're the expert. You know what law schools should be doing, and so we're just going to turn the accreditation over to you. And then just in the end, just let us know whether or not the law school is accredited or not. Like, don't bother us in the meantime. And at the end, just tell us, all right? So this led to this topic, and my colleague and I, which both, my colleague, Henry Webb, teaches at Palm Beach Atlantic University, he and I thought, what would be an interesting to study is whether or not this is even legal. All right, everyone just assumes it's legal, but it doesn't mean that it is legal. Now, one person that's not on here that I do need to give some credit to is, and not on the presentation, but on the article, is Caleb Byers, who's a UTM graduate. Caleb was my research assistant for a year here. He went to law school at UT Knoxville, graduated number 1 in his class, Order of Coif, and then he clerked on the Eastern District of Tennessee, and currently he's on the 8th Circuit Court of Appeals in Fargo, North Dakota. And so Caleb Byers is a UT Martin success story. So Caleb helped us with the article. So the presentation is, it's very long-winded. From a consumer protection perspective, the ABA should be subject to the United States Freedom of Information Act as the functional equivalent of a government agency. So this article was published in Loyola Chicago's Consumer Law Protection Journal, I want to say in 2021. And so the ABA is the accreditation power over law schools. And the ABA is a non-governmental organization, all right? And so the ABA's ability to accredit law schools is delegated to it by the DOE. Now, we didn't write this article when we were both teaching on the JD level for fear of, because we kind of call into question this power structure. And so, number one, we weren't sure that we could get it published. And then at the same time, we didn't want to create a backlash, all right? And not that there would be a backlash, but just for fear of maybe this is not the appropriate time to publish the article. So the way that the ABA site evaluation works is once a law school is accredited, it goes through an accreditation process every 7 years. And I'm sure Dr. Cavalier can tell you that this 7 years comes along about every 7 days, okay? It's not really 7 years, it's like 7 days. And as part of the ABA site evaluation, a law school, you have to submit a voluminous amount of material. And you have to, from everything from bar passage rates to admissions numbers, financial health of the law school. It's just a very arduous process. And there's a very long list of compliance standards that the ABA issues that you then have to meet, all right? And so, but leading up to this, there's about a 2-year process of correspondence where the ABA sends out their initial request, you send the information, then they request additional information, you then send supplemental information, and this goes on for about 18 months leading up to this site visit. And the site visit is actually 3 days. It's 3 whole days, and the site evaluation team is made up of law school professors, all right, other law school professors at ABA accredited law schools, and then also law school administrators, all right, deans, associate deans. And so they come and they basically embed in your law school for about 3 or 4 days. And it's very, like I said, very arduous. And there's interviews and they talk to the students and the teachers and they go through the whole curriculum. And so when in the presentation, I'll refer to this as just the site evaluation information is what I say. That'll be just kind of the catch-all, all right? And so the site evaluation information is extremely comprehensive. And the reality of it is this information actually would be of great interest to consumers, to donors. There's a long list of people who would find this information beneficial, especially, the savvy consumer, all right? So, the ABA, but the ABA designates the site evaluation information as confidential, all right? So therein lies the rub. All right, we have a governmental agency, i.e. the Department of Education, that says, ABA, you're the expert. You know best, we'll turn it over to you. This third party then comes in and does this huge site evaluation. And then what would be public, i.e. the record and all the information provided by the institution, is then declared confidential. All right? And so our position in this paper and in this article is that ultimately this harms the consumers because there's information in there that parents, law students, donors, that people should know, that should have access to, that if it was the Environmental Protection Agency, for instance, that information would be public. All right? You could file your Freedom of Information Act request. The EPA would then have to give you the information. All right? And so in every state has what we call sunshine laws as well. So state law is the same way, that you can file a request and that the state agency or organization has to turn that over. UT Martin is no exception to that. All right? If someone was to file a Freedom of Information Act request with the University of Tennessee Martin, UT Martin is obligated to turn it over by state law. All right? So why isn't this information being made available to prospective students? All right? For a majority of the site evaluation information, neither the law school nor the ABA really should have an incentive to conceal it. And I'll show you some exceptions in the Freedom of Information Act to where there obviously would be some information that would be confidential, all right, that should be protected. but I don't know if that's 3% or 2% or 10%. I haven't really put a percentage on it, but obviously there probably is some information in the report that should be declared confidential. All right, so the benefit to prospective students, our position is far outweighs the detriment to the law school. All right, that this information should be available, but it's not. And so one tool by which prospective law students could potentially obtain site evaluation information would be through the Freedom of Information Act, which is Chapter 5, United States Code, Section 552, and we'll just call this FOIA. And so FOIA, which is the federal analog of various state public records acts, requires that agencies in the United States and the federal government produce public information that's requested. All right? And so then every state also has versions of FOIA. All right. So here's what the Freedom of Information Act says. FOIA exempts, there's 9 classes of information that is protected from disclosure. But when we look at an ABA site evaluation and the information that a law school would be providing, there's only 3 exceptions that the information would fit into. Number one, I seriously doubt that there's information that law schools have that need to be protect national security. Okay, so we can throw that one out. Information related solely to internal personnel rules and practices of the agency itself, that's not applicable. Number 3 is information prohibited from disclosure by another federal law. For instance, like FERPA, there may be information in the report that FERPA would then say we can't make this public. But that's a very small snippet of information that would exist in the site evaluation report. Trade secrets or other confidential, privileged financial information, you can redact the financial information from the report. And what's interesting is that if you're a private school, every year you have to file what's called an IRS Form 990. All right, so you have to file with the IRS the financial health of the institution. You can go online and pull the IRS 990 for any private, non-profit group in the country. All right. And then could you access other law school information? Sure, through the state law, you can access financial information on a state institution. So even if that information is protected in the site evaluation report, that information would be available, all right, through other channels. Number 5, privileged communications between agency. That would not apply. Number 6, information that would violate an individual's personal privacy if disclosed. So that goes back to like FERPA, some type of personal information. Could that be redacted out of the report? And the answer is yes. Information compiled for law enforcement purposes, non-applicable. Information concerning the supervision of financial institutions does not apply. And then lastly, geologic information on wells. Okay? So, as a former oil and gas lawyer and a former energy lawyer, I can tell you there's no more powerful force than the oil and gas lobby. Okay, all right. So anyway, you can see here all these, and then you get to number 9, the geologic information of wells. Okay, all right. So, don't lose any sleep at night about whether or not Exxon's going to make it. All right, they're going to be just fine. So when we wrote this article, all right, we argue that the ABA is essentially the functional equivalent of a government agency. It is the government. It's acting on behalf of the government. Its marching orders are because the government says, ABA, you're in the best position to conduct this accreditation. All right? And so under this functional equivalency test that was first articulated in 1971 in Saucy versus David, and then the subsequent cases are very clear, even a private organization like the ABA may be an agency subject to FOIA if it acts as a functional equivalent of the government. And that's exactly what the ABA is doing. I mean, there's no question at all about it. Now, when we wrote this article, we wrote it from the perspective that when this litigation comes, and it will come, that essentially what the lawyers can do is essentially take our article and that's the brief. We have essentially written the appellate brief for the attorneys. So the Administrative Procedure Act confers agency status on any administrative unit with substantial independent authority in the exercise of specific functions. These are the findings in the 1971 case. Entities which merely make recommendations and do not have final decision-making authority are not agencies. But the ABA does have final decision-making authority. It does not make a recommendation to the DOE. The ABA is it. All right? And so, for purposes of FOIA, all right, so there's a distinction here because this is not the ABA serving as a fact finder. This is the ABA serving as the final arbiter. So this is the ABA. This is the ABA's own materials. This is the guide to law school accreditation process right here. So we argue that because the ABA itself makes the final law school accreditation decisions in lieu of the DOE, rather than merely advising or making recommendations, the ABA acts as a functional equivalent. So when a law school seeks provisional approval, the final decision on the school's application is made to the Council of Legal Education. The accreditation committee's findings of fact are binding on the Council unless the findings are not supported by substantial evidence in the record. And the accreditation committee's conclusions and recommendations are not binding on the Council. In the year that a law school is considered for full approval, the process is identical to that undertaken in connection with the application for provisional approval. Decisions of full approval are made only by the Council by reviewing the findings and conclusions and recommendations of the accreditation committee. If the decision of the Council is to grant full approval, that decision is final, and it's effective immediately upon notice to the school. If the decision of the Council is to deny, the school has the right to appeal. So that's it. It ends when the ABA says you're either accredited. If you're not accredited, then you can appeal it. All right. I'm not sure anyone's appealed it and been successful, but this is the ABA's own information. So then you fast forward to 2006 in Cooley versus the ABA, the Sixth Circuit Court of Appeals, which we're in the Sixth Circuit now in Tennessee, which sits in Cincinnati. The court explicitly stated that the ABA does perform a governmental function. So this has been to two different circuits, the DC Circuit, the Sixth Circuit. It has not gone to SCOTUS yet. But the ABA acts on behalf of the DOE and wields a quasi-governmental power of deciding which law schools are eligible for federal funds, and accrediting agencies perform a governmental function. All right. So although the Cooley Court did not state that the ABA is not a government authority and thus not governed by the APA, in making that statement, the court was considering only the appropriate standard of review under the APA. So the court never ever gets to the point where they say that the ABA is or is not. They were merely looking at what's the standard of review under the APA. And so I don't want to be too wonky here, but that's oftentimes in administrative law, the critical question on appeal is whether or not, what's the standard of review when you look at administrative decisions. All right? And so the court did not consider whether the ABA was a functional equivalent of the government agency under Saucy and its progeny. We believe that if this issue is litigated, that a court would find that the ABA is the functional equivalent. And therefore, that information that the ABA accumulates would then be susceptible to a FOIA request. It would have to be made public. All right? And so we argue that in the interest of transparency, that it only makes sense that if the ABA is operating as a government agency, then the information then should be public. If the ABA is not a government agency, then the information shouldn't be public. But you can't have it both ways. The DOE can't say, ABA, you're in charge, you take over, you do it. And then at the same time, the ABA then say, well, wait a minute, we're not the government. We're not susceptible. You can't, I hate the saying, you can't have your cake and eat it too. I've never really understood that. But the reality of it is the ABA wants it both ways. All right? They want to be independent and not a government agency, but then they don't want to play by the rules that every other agency has to provide or has to play by. All right? So why is this important? Number one is, like I've stated, transparency and consumer protection. Parents, students, administrators, all right, board members, we think that this information is available. It's not always available. All right? This information should be available. Number two, there's constitutional law violations here. All right? Because, while I don't want to go down the administrative law rabbit hole, the reality of it is we have a system whereby all three branches of government function within one, i.e. the fourth branch of government, administrative law. And that's government agencies. They're not only the fact finder, all right? They don't only, let me back up. A governmental agency proposes and publishes the rules. They then are the fact finder when you violate the rules. They then are the judge determining whether or not you violate. So all three branches of government are housed in one unit, i.e. administrative law. All right, government agencies. And then lastly, industry capture. This was also a concern of ours because how are accreditation teams set up? It's other professors and other administrators from other institutions. And so the reason we didn't write this when we were there is, like I said, for fear of some type of backlash or pushback that we would get. All right. Now, what's very interesting is this article was published in Loyola. It was then somehow Paul Karen, who's the dean at Pepperdine, he has a very successful legal blog. It's called the Tax Blog Prof. And that's probably one of the top 2 or 3. It's more than just tax. It's all types of legal issues. But anyway, he picked up the article and then he posted it. And then it had, like 2,500 shares. All right. And then he reposted it about a month later, and I don't remember how many shares there were. But then I get reports from like Google Scholar and ResearchGate. And what's very interesting is I can see who's downloading this article. And the people who are downloading this article are people who I know who are ABA insiders who are on the accreditation teams. They are the big wigs in the accreditation world. So on some level, I take great pride in knowing that this article has these ripple effects of, who's this professor from UT Martin? Who's he think he is publishing, this article? Now, the good news is no one has sent me any hate email yet or anything like that, right? I haven't gone out and my tires have been slashed or anything like that. But the reality of it is the article is being shared and it's being read. And so I'm just very interested to see, how it plays out, all right? And then, like I said, industry capture is the concept that the regulated become the regulators, and then vice versa. And so higher ed oil and gas has done it the best. Oil and gas industry has done it the best. Oil and gas experts, executives, then become regulators. They then essentially regulate themselves, all right? Higher education is very similar because the people on the accreditation team are what? They're professors and administrators from other universities. And so guess what's going to happen? In a few years, you're going to be at my campus accrediting me. So, you better, I'll take care of you, but when you come to accredit me, now remember, I was at your campus just a few years ago, all right. I'm not saying that happens, but the reality of it is it's called industry capture, where the regulated become the regulators and vice versa. And it's a concern. So so if we look at it though, this is just 6 law school failures in the last decade. Now what's interesting is Valparaiso, I had a colleague there, Middle Tennessee State University attempted to purchase Valparaiso or take it over and move it. And I don't know who ultimately nixed that in the state of Tennessee. I don't remember exactly. Dr. Keller, you may remember. I don't remember. I don't know if it was the board of trustees of the university, the regents, or they said no way. And so these law schools are all wound down. They don't exist. Now, here's what you don't know about legal education, is legal education for a century has been a cash cow. All right? So when I took Contracts 1 when I was in law school, all right, there was one professor and there was 150 students. And so you had one salary, and then you had 150 people paying $30,000 or $40,000 a year, right? So you can do the math. You've got 5 or 6 first-year law professors, and you've got 150 students that are all paying, right? And so major universities, UT, Knoxville, Ole Miss, we can go down the list, law schools have been a huge cash cow. All right, so there's a huge incentive to have a vibrant law school. So some of these schools like Indiana Tech, they attempted to get in, Valparaiso. Some of these are standalone. So for instance, Charlotte School of Law is a standalone, and it was actually owned by a hedge fund. It was actually owned by what we call Law, and it was for profit. All right, so this thing was designed to make money. We're not even going to pretend it's nonprofit. All right, we're just going to come right out and say, It's not, when people say it's not about the money, folks, it's always about the money. So my students will tell you right now, Dr. Baker will be very upfront. It's always about the money, okay? All right? So I'm being funny. But I'm focusing here on Charlotte School of Law because I think this is a great example. So in 2014, there's an ABA site visit, all right? And in 2014, there's a 72-page ABA report on the law school's non-compliance with ABA standards. This is all factual. This is exactly how it went down, all right? 2 years later, Charlotte gets placed on probation. Now, the report is in 2014. You are not in compliance. If you do not become in compliance, we are going to shut you down. This information then remains confidential for 25 months. In the meantime, hundreds of students enroll at Charlotte. They pay their tuition. They go to class. They think, I'm going to leave here with a law degree. In 3 years, I'm going to be a lawyer. Hey, Mom. Hey, Granny. Guess what? All right? Everybody's grandmother is glad that they're a lawyer, all right? You know, everybody's grandmother says, oh, Patrick's in law school, all right? So in October 2016, ABA places Charlotte on probation. Folks, in 2017, they no longer can lend federal funds. That's the death knell, all right? And so in August, right, 8 months later, North Carolina then revokes their license to be a state accredited. So they lose federal funding in the winter of 2017, and then August 2017, the state revokes their ability to operate as a state institution. And then in August 2017, they simply ceased operations. They closed. So you're coming back for your second or third year of law school, you've got your lease, this is where I'm going to go, and then in August, sorry, good luck. We wish you well. So the former students, there was actually 140 state court lawsuits, plus there was 2 federal class actions against Charlotte, i.e. Infi Law. And the lawsuits, you know, allege fraud and intentionally misleading them regarding the law school's ability to provide a legal education. They had known for 2 years that these problems existed, but this report was confidential. And so during 2016, Charlotte continues to represent that it's ABA accredited and in full compliance with ABA standards without informing anybody, any prospective students, that this report was out there. So the upper echelon at Infi Law said, we've got big problems. All right? But this information is then concealed from the consumer. And so in 2016, the DOE denies Charlotte's recertification application, and so then therefore that's the end. And then in this lawsuit in Herrera, Charlotte School of Law had improperly misrepresented its accreditation status and bar passage rates to its students, so effectively finding that they had committed fraud, that they had misrepresented. All right? And so more than 100 students were enrolled when the law school closed. All right? And so the average student loan amount for each student was about $100,000, non-dischargeable debt. So I've gone for 2 years, I'm $100,000 in debt, and now my law school has ceased to operate, and I don't have a law degree. Now these law students were able to transfer, but the problem is then you go to another institution that says you have to have X amount of credit hours in order to get a degree, and so they couldn't just go for 1 year, they had to go for 3 semesters or 4 semesters, and essentially be in law school another year and incur another year of debt. All right? So students who withdrew from the law school more than 224 days before it closed were not eligible for financial forgiveness. All right? And so then that year, of course, things in 2018, for students who managed to graduate, the bar passage rates were abysmal. 25% in February, 45.5% in July, and then 0% in 2018. So even the ones that were able, they were to cobble it together, keep a few professors, graduate this small group. The instruction was so poor that these people were unable to pass the bar. And this debt, I mean, this is just 2018, so we're talking 4 years ago, folks. I mean, it takes a decade, 15 years to pay off that type of student loan. I mean, these people are still saddled with this debt based on this type of malfeasance. So the bottom line is had this information been available in 2014, hundreds of people would not have enrolled in Charlotte. Now, would that effectively have ended Charlotte? I understand the counter argument would be that these were findings that if you don't get in compliance, you're going to lose your accreditation. But guess what? I mean, I think you have to err on the side of protecting the consumer here, that the consumer deserves to know. And that way, if they do enroll and Charlotte says, well, we're going to turn it around, don't worry. And you do enroll and it closes, at least you went into it without blinders on. You said, I knew that the school was on probation. I knew that there were problems, but I took that risk versus having it concealed. All right? So one of the things that we did that was fun is Professor Webb went to Lewis and Clark in Portland. And so just to run a flag up the flagpole, we actually filed a federal Freedom of Information Act request, and we requested Lewis and Clark's site evaluation report. All right? On May 2020, the ABA Senior Associate General Counsel replied to us, the ABA is not an agency of the government and is not subject to FOIA. So we actually, if we wanted to, we actually could file the lawsuit ourselves. He could file the lawsuit. He's injured. He's requested it. He's an alumni. He has an interest in the financial health of the school. He has sustained an injury by this denial. If we want to, we could file the federal lawsuit ourselves, all right? Unfortunately, I have other things to do, all right? Things that are more fun and less costly than filing a lawsuit. But it actually would be the perfect venue, which is the Ninth Circuit. It would be the perfect venue to file this. And then, in our free time, all right, if I didn't have 3 kids in my free time, I could do it, all right? But anyway, I don't have a lot of free time. So, but we requested it. And so the reality of it is whether there's some type of government reform, litigation, the bottom line is our position is that this information needs to be public, all right? And I'm not saying all the information needs to be public, but what is confidential or what is sensitive can be redacted, all right? Information about the financial health of the institution, bar passage rates, all that information should be public. People should have access to that information, and the consumer should then be able to make a better choice, all right? So, all right, so that's it in a nutshell. And then if you've got questions, I'd love to answer them. Go ahead, Dean Tatunchi.
Yes, sir. Patrick, has ABA ever presented any rational argument on the record why they do this? Why they keep it up?
Well, what they claim. Oh, sure, absolutely. So Dean Tatunchi asked, has the ABA ever articulated why they do it? And so you can actually, I've got the letter, but the letter from the ABA specifically states, we don't have to comply with your request. We're not an agency. And so they didn't go into the reasoning or the logic other than simply, we're just not an agency. But our position is, but you're doing the function, you're operating as the DOE. So which one is it? Are you an NGO or are you an agency? But you can't bounce back and forth. Yes, ma'am.
I'm gathering that they don't have to turn in a full report to the DOE because you could then file the Freedom of Information Act to the DOE.
You're exactly right. So so the question is do they turn the whole site evaluation report over to the DOE? What do they turn over? And what essentially they turn over is like a 2 or 3 page letter finding that the law school was in compliance, they meet the standards, and given the stamp of approval for the next 7 years. So if you did request that from the DOE, what you get is just, a minuscule amount of documents compared to this site evaluation report, which actually has the real meat in it. Eric. So Eric's question is do I see any transparency from other law schools that essentially go above and beyond what they're required to do? I think that, I hate to say this, right? So part of me, just being an attorney and a litigator, right, I'm slightly jaded in the sense that I think law schools enjoy this consortium, right? Kind of like OPEC, all right? They enjoy the fact that they can, essentially set the tone. There are federal regulations now where law schools do have to publish, for instance, on their website, their bar passage rate, their scholarship retention rate. So one of the things I will say is there is more transparency, all right? but we just still have a long way to go. And I've been out of that game now for 6 years, and so I'm not really up to speed on is there more transparency or not. I will say that when I work with students advising them about law schools, I still find it very difficult to find out basic information. And so, for instance, Ms. Gurnt, you were in my class, and you and I, we went and we looked at a couple different law schools, right? And so she and I were able to find some information that was helpful to her, but it was like 2018, 2019, and then the information was hidden, and we had to go to the website. So it's on the web, but now is it readily available on the web, or is it buried on page 542? So I think there's been some strides taken for transparency, but I think we still have a long way to go as far as helping consumers make the best choice, right? And then if they still do it, then that's on them, right? Like if I knew that Charlotte Law School was in trouble and I enrolled there and then it folded, that's on me. All right? Go ahead, Dr. Cavalier.
So first, very interesting. Obviously, we're in our reaffirmation accreditation. So one of the things about having been selected as the featured faculty scholar is that you get to be in Cancun for 1 week.
Oh, great.
Like Sachs is here.
Yeah.
So this argument doesn't slip out.
Right.
But in any event, so what you said about Charlotte Law School, it seems to me that every school could game the system if we were required to make it public. Like our accreditation document was 400 and something pages. That's not going to help the consumer.
No, it's not.
But what you showed there is that Charlotte Law School said we are compliant with all ABA standards.
Right.
So, I mean, is it really is the thing that's going to help the consumer that all that information is there? Because we can dump as much information as we can.
I agree with you.
Figure it out, or is it we have to say after the site visit we are not compliant with certain standards of X?
Well, and I think that's a very good, I think you make an excellent point. And so Dr. Cavalier's question is it really not access to the site evaluation information, or is it the fact that the information may be so overwhelming the consumer can't decipher it? Is that accurate? So I think that that's a valid point. And so, you can file a discovery request in litigation and a semi-truck show up with hundreds of bankers boxes and you're looking for 3 emails and you never, so I understand how to game the system. I think that that's a valid concern. What I would say is I think there's probably other non-governmental organizations or watchdog groups that could help decipher it, number one. But then number two, I agree with you, right? Does there need to be then further regulation or direction on what do we need to publish out of the report, right, for the consumer? And so kind of going to Eric's point, law schools now have to publish their bar passage rate and that type of information. Scholarship retention rate is a big one they have to publish. And so, that would probably be the ABA's argument, actually, right? So the ABA would probably come back and argue we could publish all this information and get away, but we're actually required to do all these other things that the consumer really wants to know, like bar passage rate, debt load, and all those things. And so, but when I look at, when I go back and I look at Charlotte School of Law, obviously the information that they were required to publish, and then there's a disconnect because they were able to say we're in full compliance. And so there's obviously a gap there in the regulations, or just it may be just a lack of oversight, right? The regulation may be on the books. It's just simply there's no enforcement. So, I mean, it's definitely not this is not, I don't think we can look at this and say this is the blueprint or the gold standard. I just think it's one tool that I just don't think you can have it both ways. I don't think you can operate like the government and enjoy that protection, but then not comply with what the government has to comply. So are you a non-governmental organization, third party, or are you the government? Which one? You pick. But no matter which one you pick, you have to play by those rules. And so, our argument really is just kind of basic kindergarten stuff, follow the rules. Really, at the end of the day, it's very simple. So we wrote this article, like I said, that if it's litigated, you can essentially take our article and then that is the brief that you could file with the federal court, because we go through the cases and the prodigy cases and stuff like that. So, like I said, what's interesting is the amount of reads, the amount of time it's been shared, and then the people who are now downloading the article. which are ABA, accreditation insiders, experts. So, and no one has sent me an email saying you guys are completely crazy, ludicrous, you've got the law wrong. No one's done that either. So that tells me that we're not completely I haven't completely lost it. Anyway. But it was a great project, like I said, and we've gotten a lot of reads out of it. And I haven't looked at SACS, and I don't know the relationship of SACS and the DOE. Right.
So I'm gonna send you the reviewers.
Right.
For our visit, their names, and you tell me if they downloaded them.
Great. Well, if there are additional questions, I invite you to come up and talk to Professor Baker individually. But before we end, maybe you'd put your hands together and thank him again.
Thank you all. Thank you. Yeah, I appreciate it. I hope it was good.